Judge President, may we have your full names, please?
Good morning, everybody. I'm Selby Mengo-Mbenenge.
You have an objection against taking an oath?
Not at all.
In which case, do you say that the evidence you are about to give will be nothing else but the truth? And if so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. Before I address my questions to the respondent, the JP, may I indicate that there is a file that is placed before the panel. It's not anything new. It's a file so that it's convenient. It does make reference to the specific pages in the record, in the volume. It's just that it's the sequence of his own testimony. And so it's not a file with new documents at all. And so you could keep it there just for his own reference, for his own sequence. Secondly, Chair and members of the tribunal, let me indicate before I start that I'm going to deal with 4 themes. The first theme is going to be just a theme about, it will become relevant, it's about himself and who he is. That's the first thing. And that would cover just his career and this complaint. The second theme is going to be the issue that is right at the heart of this, or one of them, which is the incident, the so-called incident of the 14th or 15th of November. And the third is another one which has become an issue, which is the picture that the respondent, the JP, is alleged to have sent. It's K8. We've been dealing with it as K8. The last big theme that we're going to talk about is the chats themselves. The sub-themes of which are the general flirtatious chats, and that's common cause. And the second sub-theme in that theme is the complainant's own flirtatious chats. And this will be found in volume 1 that we've always had. And so the files that are going to be important largely in this testimony is volume 1, volume 3, and you'll be taken through that using the file that's been given to you with references. Thank you, Chair. May I start?
Yes, please.
Judge President, if we can start with who you are, your career briefly, and I'm not going to ask you about your character because we know now we're not going to deal with character, but just who you are, your history, becoming a judge president.
Thank you, Counsel. I was born in Butterworth. I did my primary education there, and then I moved to Umtata when my parents moved to Umtata. I studied at the University of Transkei, 2 degrees, firstly B Juris and thereafter LLB. Before being an advocate, it was a bit of a winding road, if I may put it like that. I was a prosecutor at some point. I was a state law advisor. I was a lecturer. I then joined the bar after undergoing pupillage at the Joburg Bar. I became an advocate for 22 years, 11 years as junior counsel and 11 years as senior counsel. I became a judge on 1 July 2015. And then in 2017, around May, I became ADJP in Umtata. The post of JP fell vacant. There was the first bout of interviews that were conducted. 4 of my colleagues were nominated. That process yielded nothing in the sense that no recommendation was made by the JSC. I availed myself. I became JP after undergoing the usual interview. I became JP on 1 November 2017, if I remember well. So basically, that is my pathway to being JP, from the academic side of things and from the professional side of things.
Could you just tell the tribunal briefly about challenges that you may have faced by becoming a JP, Judge President of a province, just after 2 years as a judge?
Maybe before I deal with that, Counsel, I hope it won't derail you. One of the documents that I will be referring to at page 10 of the consolidated bundle that I believe has been availed to everyone concerned. One will see that there is reference to Form 2. It says it is alleged that the facts set out in Annexure A to this notice constitute a complaint of incapacity, gross incompetence, or gross misconduct against you. In other words, it is as broad as all that. And one is not sure exactly why there is reference to incompetence and incapacity. But to the extent that there is maybe an allegation about incompetence, I can only refer to my CV, reported cases that were penned by me, and so on and so forth. But I don't want this tribunal to be carried away when it comes to that. It suffices basically to say, as counsel, I have to my favor 48 reported judgments. I'm not talking about judgments in Sefli, I'm just talking about reported judgments. You will see that the last of those, number 48 at page 5, is Poswa versus President of the RSA. And then as acting judge, when I was acting from time to time, I have 9 judgments, and I have made reference to some other authorities where those judgments are referred to. And then as a judge, I have accumulated, I'm just saying as a judge, I've accumulated 13 reported judgments. And as JP, I have accumulated 6 judgments. That is those that are reported. There may be reference to some in the course of what I will be saying, to the extent that, as I have said, mention has been made of some incompetence. I don't know in what context. There are publications that I point to at page 9. Transformative Constitutionalism, a Judicial Perspective from the Eastern Cape. It's published in the University of Fort Hare Law Journal. And then the other one, A Dead Horse Need Not Be Flogged, The Duty Not to Pursue Unmeritorious Causes, South African Judicial Education Journal, Volume 1, first issue 2018.
JP, can you pause a little bit? You're referring to a document. Which document is that?
Can we go to the bundle?
Bundle? Page?
Bundle, let's go to the bundle. Page 3. This is the consolidated bundle.
From page 2 of what is before us is the complaint itself. Are you referring to that?
No. This is the bundle that I believe was submitted to the panel this morning. It is under index further supplementary bundle for use during respondent's testimony. Has the chairperson found that? The numbering is twofold. There's numbering for the particular bundle, and then on the right-hand side to the general bundle or index. Has the chairperson located the index further supplementary bundle for use during respondent's testimony?
Yes, it's that one.
Correct. So, should I follow the small pagination?
Yes, there's the small numbering. You will see, Chairperson, that page 1 is the CV. Page 1 is the CV.
Yes.
I've mentioned something about it, Chairperson.
Yes.
And then page 3 are reported cases since I joined the bar. There are about, let me say, there are 48 of them that I could
Yes.
pick up.
Correct.
I don't want to delve into that.
Yeah.
I'm here as a judge otherwise. And then as acting judge, because from time to time I acted as a judge, you will see that there are 9 reported judgments.
On page, smaller page?
Small page is 5, 6, and 7.
Yes.
And then as a judge, starting with Gongose, up until S versus Jolingana, 13 reported judgments that I could pick up. And then as a judge president, there are 6 reported judgments at page 8. I've highlighted some of those because in the course of my testimony, I may refer to some of them, but it's just highlighting.
Yes.
You will see number 10 at page 8, number 2 at the same page, pages 5 and 6. The last reported judgment is sustaining the Wild Coast, NPC and 8 others versus Minister of Mineral Resources and Energy and 4 others. And then above that is Minister of Police versus Sheriff Mtata. I will say something about that. And then at page 9, these are publications in law journals at my instance that I penned. The first one was published in the Forte Speculum Juris. The second one was published in the Sage Journal. And then the third one was published in the Obiter, which is a law journal of the university or Nelson Mandela University, NMU, Gqeberha. And then the one paper that I read that I thought maybe one should refer to, South African Perspective on the Interplay Between Freedom of Religion and Human Dignity. I read a paper at Brigham Young University in Provo, Utah, United States of America in 2018. So much for that. So much for that, Chairperson. Thank you for your patience.
Yes.
I thought, Councillor, should refer to that insofar as broadly there's mention of incapacity and incompetence. I don't know why.
Yes. Chair, you will see that that is a reference in small page 10 of that bundle. There is some insinuation, in fact, express thing about complaint of incapacity and gross incompetence. And so it's mentioned not to boast about what the respondent has done, but to deal with that kind of accusation. You interposed that, JP, when I was asking you about what challenges did you face on becoming judge president when you had just been a judge for 2 years.
Chairperson, leadership
Judge
in and by
President.
itself is challenging. And I wouldn't love to be seen to be suggesting that there are challenges that beset me, particularly because I had been a judge for 2 years when I became JP. But there are a few peculiar things that I would like to mention that I would like the tribunal to note. These may be situational. It might be that some of them came about during my era as a judge president. The first one has to do with introduction of a judicial case flow management dispensation, a uniform one at that. When I became JP, there was no case flow management in Makhanda, which is Grahamstown. There was something that was done in Bisho and Mtata, but what I championed was introduction of a uniform case flow management dispensation. What I would like to say is that the article that is referred to in the CV, the one about judicial case flow management checkpoint, how far have we gone, which is published in the obiter. The introductory part of it deals with the challenges encountered when CFM or case flow management was introduced. The notion, especially around Grahamstown and those places like Mbebecha and Makanda, the notion that was flying around was, why fix something that is not broken? So from the perspective of some practitioners, the view was that nothing was broken and therefore there was nothing to fix. Yet we know that there are bottlenecks when it comes to the running of cases. Case flow management is meant to ensure that when a matter reaches litis contestatio, if I may put it like that, then it means it should be ensured that when the matter is enrolled, in fact, it runs. Now, to a practitioner who is enthusiastic about postponement of a matter, removal from the roll, fees are marked, and so on, the picture is slightly different. Those tend to frown at judicial case flow management. I'm just stating that purely at the level of it being a challenge. The other challenge that I encountered, and regrettably so, had to do with the media. This may sound a bit controversial. It's not a topic that I intend delving deeply into, but I think it is incumbent on me to demonstrate some aspect in relation to how I picked up a problem with the media. It so happened, or it came to pass in the Eastern Cape, that an order of court was published before it was issued. So I'm saying an order was published by a journalist before the order had been granted by the court. In what circumstances did that happen or take place? That took place in circumstances where a colleague of mine, who is the wife of a journalist, was allocated civil work during the week in question, and then I queried the colleague in circumstances where I was saying, how does it come about for an order to be published in the Daily Dispatch before the order has actually been handed down in a court of law? So this is me talking to a colleague, because the order is published in the Eastern Cape paper, Daily Dispatch. Now, I have annexed to these papers that are serving before you, Chairperson, I have annexed pages 178 to 179, the little 178 to 179. I just wish to refer to this quickly without belaboring the point, but I'm just talking about challenges, Chairperson.
Yes, let us get that page.
Small page 178, otherwise 1508.
Small.
Small on the top there, 178. At the top, the caption there is Eastern Cape Mom wins 15 million health claim by Ray Hartle, 15 July 2020. Then the article itself is at page 179, and then at page 180, we see that on 17 July 2020, there is this order that was granted. Now, there is a publication on the 15th of a court order And then there is this court order which was granted subsequently. It seems from the report that I received, Chairperson, that even though the draft order had indicated that the order will be granted on a particular day, it ended up not being granted on that day. But then the journalist concerned had sight of the order in the court file. So the issue with me involving the colleague concerned was, my sister, how does it come about for an order to be published before it is issued? This was, in my view, a serious transgression on the part of the member concerned of the bench, but life is not about rushing to the JSC and reporting things. I simply thought that it's a matter that we could discuss and deal with to a finish, which is what we did. But the response of the colleague concerned was, well, my husband does have access to the files. It's not a problem to have access to the files, but the problem is when you publish an order before it is granted. I just want to mention it and leave it at that level. So it is a challenge, Council, coming about purely by reason thereof that one is, or one had become a JP. Ordinarily,
Sorry, I don't understand the statement. My husband has access to the file.
the wife who happens to be my colleague was, well, my husband does have access to the files.
Where? In which way?
Even at home, in the study. Now, I was saying to her, it is not correct for you, my sister, to discuss cases, because the only way your husband could have known that there was this order would have either been you talking between the two of you, or would have been him having access, and the issue is about the publication of an order before it is granted. I hope that answers your question, Chairperson. If I must explain further, I will.
No, I understand. It's just that I find it strange.
Very strange, indeed. I then made reference to pillow talk. Pillow talk in the context that then, surely, ma'am, you must have discussed this with your husband, because I don't understand how it would come about for him to publish an order before it is granted. Well, we could pack that. Nothing became of that. A spirit of reconciliation between me and the colleague concerned had to prevail. But then I need to say something that happened pursuant to that, and I'm going to deal with it with your permission, Chairperson. It is that the next article that was published in the Daily Dispatch by the colleague concerned after I had confronted the wife was a concern expressed that I was not appointing silks, in particular black silks. I think there is an article on this. Let's go, Chairperson, to page 186. Page 186. You will see at page 186, there is my picture there that had been captured. And then the headline is Rao, simmers over appointment of senior counsels. Then it goes on and on to accuse me of not having recommended deserving persons to become silk. So I sought a right of reply, which I was granted by the Daily Dispatch. That is at page 191. It would be to unduly hamper the process in these proceedings for me to read line by line what is contained in the article. It suffices to merely say that I made it demonstrably clear that as soon as I became JP and was approached by my then secretary, telling me that my predecessor had been in the process of considering some applications for silk. Remember, I took office on 1 November 2017. So in January, my secretary brings this, saying to me, there is this outstanding matter, which I had to deal with. So in dealing with that, the matter followed the usual course, chairperson, which I believe is known to you, relating to how people get to be appointed as silks. I made it demonstrably clear that I had never interfered, or I had never delayed, or I had never overlooked the appointment of black silks, particularly in Umtata. So this is what happened thereafter. During a discussion involving me and Mr. Hartle about something else, and I'm now taking the tribunal to page 185. This is a WhatsApp that the journalist concerned dropped me. It dealt with some issue which is not relevant necessarily for present purposes, but can I read it for the record? Finally, I hope that you may also appreciate the extreme offense I took a few years ago when you thought it appropriate to suggest that Belinda and I engage in pillow talk about her work as a judge or ancillary issues. I don't need to read it further. I think for present purposes it suffices. It makes it clear that he took umbrage in the fact that I confronted his wife, and I don't regret I did. I don't beat about the bush. Very clearly, there was unbecoming conduct. Council, we are dealing with challenges.
Yes.
I will just deal with a few. I don't want to overburden the proceedings, but I think it's important for me to deal with one or two further issues.
By all means.
Oh, sorry, I thought somebody was saying something. One of the challenges then related to a directive on default judgments that I issued. Within legal circles, I think it is known that previously default judgments served in motion court, regardless of whether evidence, oral evidence would be led or not led. So consequent upon the delivery of a judgment by the ACA in a matter, I think it's EFF versus something, that judgment made it clear that claims founded on unliquidated documents should not serve in motion court. The reason is not far to seek. Motion court is a speedy process, and sometimes the proceedings are hamstrung by reason thereof that evidence must be led because the claim is founded on an unliquidated document, or it's an unliquidated claim, so to speak. But may I take the tribunal to page 163. This is a judgment of the full court in Umtata. Page 163. The judgment is actually not a very lengthy one, but I'm just, for present purposes, going to deal with what is set out at page 164. Maybe starting from page 163. Brooks J., who penned the judgment, mentions that on 12 April 2021, the JP issued a directive in the following terms: directions governing the setting down of undefended, unliquidated claims for damages. I'm not going to read the directive itself, but what is very important for present purposes, to the extent that I'm called upon to say something about challenges that beset me as a JP. We go to page 164, paragraph 2 of the judgment. It says the 6 matters before this court are all applications for judgment by default against the Minister of Police, in which unliquidated damages are claimed. Notwithstanding the promulgation of the Judge President of the directive 2 weeks earlier, on 28 April 2021, these matters appeared on the roll in a motion court in Umtata, over which the Judge President presided. He issued a composite order in respect thereof and in the following terms. Now, later on, something will be said about a lecture that I delivered relative to default judgment applications. But I'm not dealing with that at the present moment, Chairperson. I'm simply responding to the question posed by counsel in relation to what challenges I encountered. I'm merely demonstrating that you issue a directive. The directive is not necessarily challenged, because if you read the judgment further, it was not challenged. But the issue was, why would practitioners, after a Judge President had issued a directive, believe that they are still entitled to set a matter down in motion court? This is exactly what happened in this instance. I'm just responding to the issue about default judgments as something that became a challenge for me as a JP. And as I've said, I will deal with this in another context at some other point in time.
Sorry, if I may just ask, was that matter then entertained?
The full court?
Even though the claim was unliquidated?
Yes. So those matters served before me. I did motion court in Umtata on that day, notwithstanding the fact that I had issued a directive. Practitioners, for some or other reason, maybe one will read the judgment and see why they thought they could still do that. Those matters served in motion court, notwithstanding the fact that I had issued a directive. I trust that allays the concern of the chairperson, or it answers the question which has been raised. The point of substance is simply that I issued a directive based on authority handed down by the Supreme Court of Appeal, and that directive was pointing those cases to another court which I had created specially for practitioners. But I'm saying, notwithstanding the fact that I had issued a directive, there are practitioners setting matters down in motion court. I was in that motion court, and I consolidated those matters, placed them before the full court. The full court dealt with the matter in the manner set out in the judgment that I've referred to. Thank you, Chairperson.
I understand. Thank you.
JP,
Let me then just finish up on the issue of challenges, if counsel doesn't mind. There is also the issue of being perceived as a gatekeeper when you are JP. I must concede and confess that, having been trained as an advocate and became senior counsel and eventually became a judge, one might have had this perception that I belong to the conventional school of thought, in the sense that, as most of us will remember, way back then, practitioners who ascended to the bench were mainly senior counsel. I'm just mentioning that in passing, Chairperson. I may have come from that school of thought, but I learned a lot of lessons, which is that magistrates can act, attorneys can act as judges, junior counsel can act as judges. So the challenge that I had was firstly the perception that I am focusing more on silks which did not find support in real terms. Even when I was approached by representatives of the magistrates society expressing a view that they don't see magistrates acting, my response was, Mr. X and Mr. Z have acted as judges during my era. So there is this pressure emanating from people believing that they are judge material and that they must be considered for acting appointment. Some of us look at judgeship differently. You are a judge because the constituency that you serve believe that you are judge material. Not this thing about people who keep on knocking at a JP's office believing that they are entitled to act. And this is the story of my life. I don't want to deal with that, Chairperson, but I'm just sharing it. It is a challenge that besets JPs generally from time to time. But the issue of gatekeeping becomes relevant to some extent in these proceedings, in the sense that even among colleagues who have got aspirations to serve at the SCA, Concord, Labour Appeal Court, you are easily perceived to be a gatekeeper in the sense that, and this is my philosophy, if the leader of that particular court believes that you should act in their division or in their court, my philosophy is that please declare judgments that are reserved. Declare that you've got partly heard matters. It is an issue that sometimes gives rise to problems. But it is not a very serious problem to the extent that I have made it clear to the heads of those courts that the stance that I adopt is that I call upon judges, when they are approached to act in those courts, to declare reserved judgments, to declare partly heard matters. Maybe something that may become relevant at a later stage, which I would love to deal with. Let me look at the index on the issue about acting appointments in the context of who acts as an acting deputy judge president in the absence of a deputy judge president. I'm going to deal with that quickly. It should not detain us for long.
With regard to the perception of a judge president being a gatekeeper, if this would be of any comfort to you, that is the perception, that had been the perception around almost every judge president. I personally lived with that for the 14 years that I was the judge president.
Until you retired.
Correct.
Yeah, you never win there.
Yes.
You never win there. At the same time, it's all a matter of controlling it. You try as much as possible to deal with perceptions, but you don't win. But what is important for present purposes, thank you for interposing, Chairperson. What I would like us to go to now is item 30 of the index, pages 192 to 193. It's going to become relevant, pages 192 to 193. Page 192, small 192, 1722 of the main bundle. I'm just going to read the second paragraph. It's a letter penned by the Wild Coast Attorneys Association, attorneys in Umtata, basically. Paragraph 2 of the letter reads, I will try my best, Chairperson, not to mention names. I've seen how things have unfolded. Where I must mention a name, I will, but where I believe it is not necessary, I won't. But if you read the letter at page 192, the second paragraph, I'm here dealing with challenges. We hereby kindly propose that you consider the judges who are appointed, who are appointable, should there be a vacancy, and who are conversant with the practice within our jurisdiction, such as, then they mention 2 judges. Now you will see that the concern here is that I had appointed a particular colleague as an acting DJP. So, next page, page 194. Actually, we are going to page 195.
Just a second. Sorry, yes.
Thank you, Chairperson. At page 194 is a letter that I wrote to the secretary of the association concerned. Let's rather go to page 195 at 4.4. I am saying, is it being suggested that the ADJP is not appointable? If so, what criteria have been invoked in order to arrive at that conclusion? On what basis is it implied that the ADJP is not conversant with the practice within our jurisdiction? The ADJP concerned is somebody who practiced law for many years. He had become silk. He was steeped in civil procedure and civil trials. Somebody whose trust in whom I reposed my trust. And then the next letter.
Sorry, you were referring to paragraph which paragraph?
I was referring to paragraph 4.4. This is where I engage the association concerned to come out clearly in relation to what exactly their problem is or was. But then we can go to page 199. 199, small 199, otherwise 1729, which is on the top right-hand side. 199, paragraph 12. The association concerned responds. They say, this particular judge is junior to many of the judges in Umtata High Court. His selection to act as DJP is both unreasonable, thoughtless, and humiliating of the judges in Umtata High Court, some of whom are senior to him. Even when looked at in terms of succession planning, the judge, and I'm not going to mention names, cannot be relied upon to be elevated into judicial leadership in the future, even apart from his demonstrated oppressive style of leadership. His age rules him out. Now, these are practitioners writing a letter about and concerning a judge. All I did, as will appear at page 201, I forwarded the letter to the judge concerned and requested him to favor me with his response. Then, moving a bit forward, page 209. Page 209, paragraph 17. The judge concerned deals with the issue under attack. He says, if age is anything to go by, they must ask the JSC why a judge over 70 years was appointed as DJP in one of the divisions in this country. That was his response. But let's read the last paragraph of his letter, some form of lamentation because of the attack by the association concerned. Paragraph 19. In conclusion, I must say it is regrettable that these attorneys decided to choose an arrogant manner in the tone of their letter, which is disrespectful towards me and an insult to you, me as JP, and the minister for recommending and appointing me as DJP, instead of, then he mentions judges. And finally, on this point, yet another society called the Mtata Society of Advocates saw it fit to straighten the record. Could I take the tribunal to page 210B? 210B. I don't want to read everything, but it is a letter that deals with the various concerns that had been raised. Paragraph
Sorry,
6.
sorry, just as a minute. Page 2.
Page 210B. On top is 210, capital letter B. The JP's discretion to appoint an ADJP in one of the Eastern Cape High Courts, they deal with that. Then they say the JP's appointment of, they mention the judge concerned. Then they say, I am being accused of overlooking some of the colleagues, they mention their names. And then the JP's reviewing of the decision to appoint, they mention the judge's name. And then something is said about robing by advocates in the lower courts, something that should not concern us at this point. Now, they say at paragraph 7, at the outset, it must be said that we feel very uncomfortable that the names of our two esteemed and honorable judges are a subject of this debate, and probably without their knowledge or consent. We regret, however, we are forced to do so. So the Mtata Society of Advocates was expressing, they were expressing their disquiet insofar as certain judges were mentioned in a letter as being persons who should have been appointed. But most importantly, at page 210, capital letter C. They refute the suggestion that other judges have not been considered for acting as ADJPs. And indeed, they are correct. And this is what they say at page 210C. By way of narration, in the past 3 years, we have had the following justices appointed as ADJPs: Justice Makaula, Justice Bloom, and Justice Dawood. I mention those because there's nothing really controversial, in my view, about that. Sorry to have taken long, but I'm about to round off on this issue about challenges. I have dealt with the issue of gatekeeping, or the last one that I would like to mention, not necessarily because really it's the last thing that one should mention or can mention. There was a name change of Grahamstown to Makhanda, which was challenged by the residents. That case was not successful. The name Makhanda remains instead of Grahamstown. Now, in the course of that, I then issued a directive in terms whereof Port Elizabeth became Gqeberha Court, Gqeberha High Court, in terms whereof Makhanda became Makhanda High Court instead of Grahamstown. There was an issue in the Daily Dispatch, Eastern Cape Herald, within the context of the name change and my changing the name of the court to Makhanda. Just mentioning that quickly in passing. But most importantly, I have had to encounter challenges relating to the recommendation made by Justice Mbenege that the seat of the High Court should move from Makhanda to Bisho. The stance of the judiciary in Makhanda under my leadership and the stance of the judges generally was that, brothers and sisters, let's keep away from this debate. We serve the constituency wherever they are. The matter of where the headquarters is not a matter that really should concern us, more so that it might become the subject of litigation. As was the change or name change to Makhanda, it became the subject of litigation. It was the subject of an application for leave to appeal to the SCA. And so the stance adopted was that much as individually people may have preferences as to where the headquarters is, but fact of the matter is the judiciary can only place it on record that, and which is what I did before Mbenege J, that on the issue of where the headquarters should be, the voice of the practitioners is paramount. The voice of the constituency that is served by the practitioners is paramount. There's been pressure on me to say something. Chairperson, I will not say anything about the move from Makhanda to Bisho. I will serve the judiciary wherever the headquarters is. It is a matter to be decided on by Parliament. It is a matter to be dealt with by the relevant functionaries. Mbenege J has made a recommendation. It's served before the JSC. As to what the politicians will do about it is a matter that should concern us, really, as the judiciary, especially as I've indicated. It might become the subject of litigation, and we will have stated our views in relation to that, which may lead to problems. Thank you, Councillor.
Thank you, JP. Let's move closer. You said to the tribunal that this topic, as relevant as it might seem, will become relevant when we deal with another theme. But let's get closer to the meat of this issue.
Thank you.
The accusation that you are here about leads to some kind of description. One's description of one as some kind of barbaric, sexist, misogynist. And in that context, because that's been the label generally you will face, I want to ask you this question. What is your personal view of women?
Those labels are hateful.
In fact, let me add, what
But
do
let
you
me-
see women as?
Women are as important as everybody else is. I respect men, I respect women. Because we are talking in the context of women, I value women. I'm born of a woman. I was raised by a woman. But on this issue that you've pertinently raised as to the perception, I've had to endure those labels. This is the third year now, and I'm happy that I've been afforded the opportunity to come here and ventilate myself in relation to that. Chairperson, I have appointed females to act in my division. I have encouraged secretaries to study law. So much so that one person who was once upon a time my secretary, I encouraged her to study LLB. I am proud to say at this moment, she's practicing as an advocate. I have delivered lectures to aspirant women judges. I don't have to come here with statistics to show how many women were appointed to act as judges from magistracy, from ranks of attorneys, from ranks of advocates, from ranks of academia. Those are things that I have done. And yes, maybe the less said about those hateful labels, the better.
Well, JP, let's get straight to those. Because the real question that I want you to deal with is, do you see women as some kind of objects for your lust, or people with whom you can have meaningful relationships, romantic, platonic, or professional? What do you see them as?
I see women as persons who can engage in whatever form of relationship. And what is important is for them to be treated as persons. And this notion that I look down upon women in the manner in which you've articulated, I submit, or let me say, has no factual basis. So I see them as important as everyone else to enter the legal profession. You probably would, when reading some of the judgments that are reported, many a times I led females as silk. I was one of those persons who were very passionate about pupillage and lecturing pupils, including female aspirant advocates. I hope I've captured the essence of your question and have proffered an answer that covers everything.
Well, let's take a step further from that, because let's get closer to the complainant. During the evidence in chief of the complainant, we heard so much about the concept of the fact that you are a judge president, power relations between you and someone who's either not a judge or not your age, or not a judge president or a clerk. In those parts, you are a judge. And there's a theory that a person who's as old as you, who's a judge president, as you are, who's a judge, cannot and should never seek to have a romantic relationship with a person of a lower class, age, status, category at work, or with less than you do. Could you favor the tribunal with your answer to these questions?
That is a notion that is hard to fathom. The notion that a judge cannot have affection. I just say affection, or may not be interested in somebody. I believe that there's a fallacy when it comes to that. I think what is important is to view people as adult individuals. They are free to engage in whatever form of relationship as long as there's mutual consent. Your question was a bit lengthy. You mentioned something about age. When it comes to age, all I can say is I would never query a woman who is older than a man in a relationship. I would never query a man who is much older than the female party in a particular relationship. I don't want to say age is a number. All I need to say is what is important is that the adults that I've just mentioned are free to engage in whatever relationship they would like to for as long as they are adults.
What is your response to the theory that you are a judge president or you are a judge? You should not seek to have any romantic engagement with someone below your class?
This thing about class distinction during this age and era is something that I look down upon. I don't believe that a JP, when it comes to engaging in whatever relationship, they are confined to persons of the same class. They are human beings, and they are judges in any event. Let me rather not even say anything. Let me just mention it in passing. I know of judges who married their secretaries in this country. Heavens did not fall.
Well, the answer will be two wrongs don't make a right.
I don't
For those
believe
who
there's
believe that
I
it's
don't
wrong.
believe that there was anything wrong.
Right. Let's come again to the entire concern that has been a running theme about this. That this entire case concerns a painful, rather painful saga of sexual harassment, as described in legal terms, objectification of women, and maybe a humiliating experience both you and the complainant may have gone through. Let's get to the meat of it. Your flirtatious, salacious conversation with the complainant, how do you describe them? What were they and what was their purpose?
It is indeed true that it came to pass that I became interested in relating with the complainant. And I don't believe, can you just ask the question once again, because the nub of it I just want to follow.
Is what was the purpose of the conversations?
The purpose of the conversation, firstly, flirtation, the way I understand it. Flirtation is actually a playful way of interacting with someone that you are interested to have a relationship with. So flirtation is a playful way, informal, where you interact with someone that you are interested in, and this is what happened in this instance.
Yes. Mr. Matansela's obsession with tea tells me that it's 11. Chair, I don't know whether this is the right time to adjourn.
Maybe let me, if Chair can allow me, just to round off my answer.
Yes.
I'm a member of the judiciary. The complainant is a member of the executive arm in that she's employed in terms of the Public Service Act. I am not her supervisor. I am not an employer. I am not an employee. Members of staff under the OCJ as a department have their terms of employment, terms and conditions of employment regulated by the Public Service Act, which doesn't apply to me. You may listen to the rhyme and rhythm as I talk about this, but I'm just mentioning it purely at the level that things are just like that. I'm a member of the judiciary. I'm not the supervisor. I will elaborate on this when we resume, if need be.
Thank you, Chair. Because I'm going to move to the next theme, I would think this is the appropriate time to adjourn with your leave.
It is. We'll come back at 20 past.
Thank you, Chair.